Good afternoon, colleagues. Welcome to the South African Bar Association Thursday program. Today's speaker will be Advocate Themba Khaba. He has obtained his LLB degree from UNISA, and his call to the bar was in February 2009. And his areas of practice include, amongst others, administrative law, commercial litigation, arbitration law, constitutional law, corporate and commercial law, customary law, the law of delicts, educational law, employment law, human rights law, local government law, persons and family law, and construction law, insolvency and liquidations, general civil litigation, and general motion court work. Themba has also appeared in high courts, the Supreme Court of Appeal, the Labour Court, and the Labour Appeal Court, the CCMA, the Educational Labour Relations Council, the South African Local Government Bargaining Council, the General Public Service Sectorial Bargaining Council, Safety and Security Sectorial Bargaining Council, and Themba has acted as an arbitrator, as a chairperson in various disciplinary hearings. This session will be recorded and will be available on our YouTube channel at the South African Bar Association. Thank you very much. Over to you, Advocate Khaba.
Good afternoon, everyone. Good afternoon, colleagues. Good afternoon to all the attendees and so forth. First of all, I'd just like to thank the South African Bar Association for allowing me to present today's topic. It's always one of those mammoth tasks when what one is always being faced with when one is being requested to present a topic or a legal topic on this platform, and I'm very also grateful to my seniors for allowing me the space to present. Okay, let's rather get the show on the road, Council and today's attendees. Well, the topic today is primarily I want to deal with the issue of customary law. Hello, am I audible?
Yes, you're audible, Advocate Khaba.
I apologize. We just had load shedding at chambers, but it seems like we're now back to normal. I apologize about that. But as I was saying, before the interruption of load shedding, the issue at hand that we going to be discussing at length today is the recognition of the customary marriage. It is important, but when I was preparing, I wanted to not only end at the recognition of the customary marriages in terms of Section 120 of 1998, but also I went on further so that we can have a look at the validity of the marriage as well and the consequences of it, and most importantly, the issues relating to court proceedings, where everyone basically has an issue with regards to that. So I start by saying in my introduction, practically that in today's session, besides what I've just said, I will be unpacking the requirement of the customary marriages that must be negotiated, entered to, and I'm using the word or celebrated in accordance with customary law. The or in the above sentence implies that the marriage must be negotiated or not, or celebrated, or is it a prerequisite for a valid existence of a customary marriage? So a customary marriage, in essence, is definitely one of complex in terms of our law. The constant judgments that change the definitions of various aspects of customary law, especially in the marriage part, that have gone to the SCA, should show us the complex of the customary law. The biggest problem is that we have too many cultures subscribing to various notions. The topic of customary marriage under the South African law has been debated and considered extensively through media and has become a subject of debate on television and social media. Customary marriages were first recognized in South African law through the Recognition of Customary Marriages Act 120 of 1998, better known as the RCMA, although recognized in law, the operation, the application, the substance thereof remain the subject of interpretation. That is basically the whole aim of why we are having this debate or this discussion in relating to this. I propose that I take you guys through to the requirements of a valid customary marriages, and together with the important issues of how the SCA looks at customary marriages, as well as I will also make reference to certain judgments, reported and unreported judgments. Should anyone wish for me to share those judgments, I would gladly share those judgments and the full citation thereof on request if one requires such. But I'll just propose that I go through what I have prepared, so to allow everyone thereafter to have questions. We can have then an open question session thereafter in relation to what have I presented. Looking at it, the requirements of a valid customary marriage is defined as a union that is negotiated, celebrated, concluded in terms of the indigenous African customary law. It's an amazing part of South African law, which governs the law relating customary marriages. Section 3.1 of the recognitions of customary marriage sets out the requirement of a valid customary marriage. These are, for a customary marriage is entered after the commencement of this act, must be valid to the prospective spouses. They must be the age of 18. Both must consent to the marriages under the customary law. The marriage must be negotiated, celebrated, entered in accordance with the customary law. They seem pretty much easy when one is basically dealing with these requirements of a customary marriage. However, the challenge becomes in practice, where one has to now interpret what is being said in terms of Section 3.1b and put it into action, and always put it into words that basically will suit one client's needs. I always make mention to say that what I'm going to be presenting is goes with the notion of saying, if one starts drafting an application in relation to this matter, it is out of paramount importance that you understand your client's vision, and most importantly, be able to set out explicitly what you require the judge to look at in your notice of motion. And that is where majority of litigants tend to not be in a position to clearly set out what one requires for the judge to make a certain pronunciation, to make a certain order, or to determine a certain relief that you want seeking. So firstly, before everyone drafting or presenting a founding affidavit, it's important that you look at your client's merits, how it happened, why are we bringing the application, what is the purpose of bringing the application. In having said that, I would just want to look at to discuss what the SCA's interpretation of Section 3.1b of the Act. The SCA regards it as wide, and it is evidence in our courts that it takes into account various factors when considering whether a marriage has been validly concluded. The two requirements in Section 3.1b of the Act are fairly easy to prove, as I have mentioned. Namely, that both parties must be over the age of 18 and both must consent. The last requirement, that the marriage must be negotiated and entered into, celebrated in accordance with customary law, which the courts have grappled with. This is likely due to the vast cultural regimes in South Africa that requires different rituals to conclude a marriage. And what are the important lessons that we draw from the SCA's interpretation of Section 3 of the Act? Couples who intend to commence negotiation and intend to marry out of communal property are advised to consider approaching a legal practitioner to assist them in drafting an antenuptial contract before the commencement of the lobola negotiation. What do I say there? What they basically means is for one to say that it is utter importance that when two families or a couple intends getting married, one, they should have a discussion of how are we intending to have our marriage? Are we having it out of communal property or in communal property? If customarily, generally is regarded as in communal property, it's given, okay? So it is always advisable that one should always require the assistance of an attorney, who's a notary, who will then prepare and settle an antenuptial contract prior to the lobola negotiations taking place between both families. Because once the lobola negotiations happen, and thereafter you wish to have an antenuptial contract, it would not be legally sound. So it is of quite importance that one looks at that dimension to have that discussion and to decide as to which area and in terms of what what kind of a marriage you intend entering into. It says that the marriage must be negotiated, entered to in accordance with the customary law. This could generally mean that lobola negotiations are held and the parties are into a marriage in terms of their customs, which could entail introducing the bride to exchange the gifts. It is a portion and to enter and to be all celebrated. That creates the certain challenges that in the application as one of the could interpret this to mean that the lobola negotiations must be certain traditions that are performed, which could be very well be celebrated of the marriage, handing over of the bride and other contrary to be argued. You will find a matter which I now will deal with and which most cases align to. It's an unreported matter in a matter of M versus K, case number 2017-2016, judgment given on the 7th of November 2018 by Makgoba JP, where the issue before the court at that particular time was whether the handing over of the bride was whether the handing over of the bride to the groom's family concluded, or is it meant to conclude a customary marriage? The High Court considered whether the handing over of the bride is an element to be taken into account when considering the validity of the customary marriage, and provided that the mere fact that the lobola was handed over to the bride's family significant and is not conclusive proof that the existence of a customary marriage. The handing over of the bride is not only about a celebration with the intended feast and rituals, it also encompasses essential aspects associated with the marriage estate, namely the bari gaspedi, that is couching of a brief of both bride, the groom, and the elders' rights, which marriages imposes on them. The court regarded this as the most important and the final step in that chain. The court held further that handing over of the bride distinguishes the mere celebration from the marriage until the bride has formally and officially been handed over to the groom. There can be no valid marriage entered into between the plaintiff and the defendant, despite the payment of the lobola in full by the plaintiff. There has not been a handing over of the defendant to the plaintiff. What I'm saying here is that on this matter, the Honorable Judge Makgoba J found that by mere of not handing over the wife, or the handing over process, or the handing over celebration to the groom, concluded that a customary marriage was not officially basically concluded. There were several High Court decisions that the ruling in the similar aligned to the views held to the above mentioned case. However, we have been contrary, there's been contrary interpretations through the lens of the Supreme Court of Appeal. The most highly and most likely discussed matter was the Themba versus Sengati. It was a SCA decision, unreported, case number 24419, delivered on the 30th of April 2020, where the SCA found that the custom of handing over the bride was an important element. But the key determinant of a valid customary marriage, the SCA shared some insight into the fact that certain customs which were practiced long ago have been replaced with Western customs. The court stated that rituals of customs have never been static or frozen in time, as they develop, they change along with the society in which they are practiced. The insight of the SCA teaches us that the customs are not static. The world is evolving, and the times have changed. Accordingly, the custom have applied in ancient times cannot strictly be applied in this manner and in the form of modern age, because such strict application may result in undesirable consequences. Meaning now the court basically says that, well, handing over of the bride, we can respect and understand rituals that have to be performed, but we also ought to look at the circumstances of each case according to its own merits. This is very crucial when one is consulting with your attorneys, clients, and whoever, to not even bother yourself and attend court and oppose a matter on the strength that handing over of the bride or the celebration never took place. Out of 10, you are bound not to succeed with that application or with your argument in any court, because you ought to have looked at what are the elements of a customary marriage, which are quite clear in terms of Section 3.1. Once a lobola, both families meet and the lobola is discussed and a portion thereof has been paid, automatically that constitutes that there is a valid customary marriage. I will deal later on with the elements on practice as to what happens when parties leave each other in the midst of an existing customary marriage. In addition thereto, I will deal with another matter in Mbungela and one other, in Mkabi and others, the 2020 decision. And the SCA highlighted the importance and observance of traditional customs and the usage of that constitutes and define the provenance of African culture cannot be underestimated. Neither the value of the custom, the bride transfer, be denied, but it must also recognize that the inflexibility rule that there is no valid customary marriage is just one of a ritual that has not been observed, especially spousal consent to have been met. Could yield untenable results. The SCA held that the purpose of the ceremony of the handing over of the bride, it is to mark the beginning of the couple's marriage and introduce the bride to the groom's family. It is important, but not necessarily as a key determinant of a valid customary marriage. Thus, it cannot be replaced above the couple's clear will and intent. So it's quite clear. The intention of both parties were to basically say, let's enter into these lobola negotiations and let's basically proceed and let's get married to each other and so forth. So one cannot now say, as a result of the handing over not being basically being done, it constitutes that there's no customary marriage. So one ought to, as legal practitioners, you ought to have to look at how you couch your argument. That's why I'm saying it is also important that you look at certain aspects when we are consulting with your clients, consulting with your attorneys, and be able and be in a position to tell your client, our job is to guard and to protect your instructing attorney at all times. So what I'm saying that is evident that from the interpretation of the SCA that a valid customary marriage will be considered to have been concluded where the parties are of age, consented to the marriage, lobola, negotiations took place. To that end, one will be considered to be validly married, even though certain customs and traditions were not observed, such as handing over the bride. There's a plethora of decisions in that regard. Does the non-registration of a customary marriage affect its validity? Section 4 of the Recognition of a Customary Act. One needs to understand this section verbatim when one is handling such a matter or dealing with such a matter in any court. It deals with when the spouses may apply when registering the marriage. A registering officer must be satisfied that the spouse concluded a marriage register by recording the identity of the spouses, the date the marriage, the lobola is agreed, and the particulars prescribed. The registration officer must issue spouses certificate registration bearing the prescribed particulars. If the registering officer is satisfied that a valid customary marriage exists between the spouses, he must register the said marriage and issue a certificate of registration as contemplated in Section 4. If the registering officer is not satisfied that a valid customary marriage was entered by his spouses, she may refuse to register. This is where the problem or the challenges comes. This is now in terms of Section 4.6. Because 4.7 says a court, upon application made to that court and upon investigation instituted by that court, order the registrar of a customary marriage to the cancellation and rectification of the registration of the customary marriage affected by the registering officer. What does this mean? Section 4.6, Section 4.7. The importance of registering a customary marriage between the spouses. Normally it's 3 months upon concluding of a valid customary marriage. It is utterly important because why? It has a lot of impact in an event of death, which I will deal with it at lengthly as well. In an event of a breakup between both spouses, it does not mean that you are not now validly a customary married to the person that you've now broken up with, and now you enter into another civil marriage, which is what I will deal with. So a registration of a customary marriage between the spouses is of paramount importance. However, failure to register a customary marriage does not invalidate that marriage. So it exists. If you have not decided to register it for whatever reason, it will have its own consequences, but it does not invalidate the existence thereof. So it still exists. You are still customarily married with whoever that you entered to a customary marriage with, and so forth. I had a matter a while ago where someone phoned me and said to me, I have Mr. A and Mrs. and Miss B in front of me. Mr. B intends moving on with his life. Mrs. X wants to carry on and move on with his life, with her life as well. But there is a problem because they are both consent and agree that a customary marriage was entered into by both families and which still exists. Can I have an agreement drawn up to say that no one will bother each other? I said to the attorney that, well, you're going to have a serious problem, because if they fight, whatever reason, and you may not waive as a legal practitioner the fact that you know at the time of making or signing that, concluding that agreement, that there existed a customary marriage between the two. And whatever wishes that they have, you cannot, under no circumstances, disregard what the law says. So as an officer of the court, you are bound to then advise them accordingly, and they basically need to deal with the issues of dissolving that customary marriage instead of having an agreement which is not even made in order of court. If one at some stage disputes the validity of that agreement, it becomes a challenge. So what happens if the parties informally separate and remarries? A customary marriage is not valid because one spouse entered into a civil union with a third party. In fact, from the legal standpoint, the second marriage, the one spouse and the third spouse will be regarded null and void. So you are in a customary marriage, you elect to say, now I'm walking away and I'm now wanting to go to and marry Mr. Joe Soap, and Mr. Joe Soap to be now my legally wedded husband. But you are coming from a customary marriage. Automatically, the second marriage will be regarded null and void, even though it is a civil union, registered marriage certificate, and so forth. If the other party elects to say, well, guess what? On such and such a date, we entered into a customary marriage, which was never ever dissolved. Technically, legally, it nullifies the civil marriage. There were sentiments in the Supreme Court of Appeal in a matter of Lidwaba and others. In this matter, the deceased had married his wife customarily, then went on to marry a second wife without having formally divorced his customary law wife. He passed away in 2012 without a will, meaning he died intestate. On how his estate was to be dealt with, leaving in his estate approximately 3.8 million, although the deceased wife had remarried someone else. Her marriage to the deceased was dissolved and very much valid was not dissolved and very much valid. The fact that they both married other people does not have an effect on their initial marriage. In fact, it invalidates the existence of these current marriages. It is clear, regardless of how culture deems the marriage to come into effect, parties that no longer wish to still to be married to each other are required to approach the courts for a divorce order, severing ties into a marriage that the legal ties come into the result of a marriage. The other question should be, does a customary law marriage nullify a further marriage entered into with a different spouse? I propose to deal with this question in the following. Subsequent marriages, number one, it should be noted that spouse in a customary marriage wishes to enter into a further customary marriage. The spouse will have to approach the High Court to approve a written contract, which will regulate future matrimonial regime in terms of Section 7(6) of the Act. However, failure to get the High Court approval of the contract does not mean that the marriage is invalid. The further customary marriage shall still be valid, but out of community of property. In this matter, there's a matter of Ngwenyama and Malelane and others, the 2012 decision. SA 527, it's a SCA decision. Further civil marriages. Many couples tend to break after the conclusion of a customary, is what I was discussing earlier, and thereafter enter into a civil marriage. The civil marriage will then have no effect on the validity of the customary marriage or proprietary regime in terms of Section 10(1) and 2 of the Act. The problem arises when the spouse to an existing law marriage wishes to enter into a civil marriage with Section 3(2) of the Act. The position was confirmed by the Supreme Court of Appeal in the Lidwaba matter and others in case number 1368, in 2020 decision, which is a leading authority at this point, in fact, on civil marriage to other person while the customary marriage subsists. Spouses should also be aware that law restricts from entering into a civil marriage. However, the only requirement that there is no person married to the either parties in terms of a customary law marriage. So the problem here even goes to such an extent of what happens when a party you are married customarily to passes on. The issue is you find an event where your in-laws do not now recognize you as the legal wife, vice versa, do not recognize you as the legally customarily married to their daughter. What then do one do? One then will have to bring an application to court seeking a declaratory order to have your marriage registered and recognized. Now, be careful of this. It is important in an event of death of a spouse and you're seeking a declaratory order of some sort against your marriage to be recognized. It is important that you cite the master of the High Court. One, you would not be able to get a letter of authority, letter of executorship issued simply because one of the requirements is a marriage certificate. So one ought to have include the master of the High Court as one of the respondent. You ought to include the Minister of Home Affairs and together with Home Affairs in itself, because you are seeking an order. I've seen matters where Home Affairs is not even cited as a defendant or as a respondent in the application. What that means is you are only asking the court to say, may I have an order to say that there was a marriage? Let's say, for argument's sake, the court finds in your favor. If the court does find in your favor, the only problem is then who's supposed to register your marriage? Because you have not joined the Home Affairs, where you are requesting the court to now seek and make an order directly, the Home Affairs to now register that particular marriage. So it is quite important. That's why I was dealing with this aspect to say that earlier on, to say one needs to be careful when we are drafting papers and you need to make your relief that you are seeking be very well known at first instance, and always before drafting, look at it both ways. Consider Paja at Paja, the Paja, and you need to look at the merits of your matter. You need to consider, why are you bringing this application? In most instances, it can materialize that during consultation, you realize that there's a dispute of fact. It is really pointless to bring an application. Even though Section 4.7 says on application, you one out to approach an honorable court and says, I am seeking a certain relief. But if your merits and what you are discussing, you foresee that there's going to be a dispute, you ought not to approach the court on application, rather issue a summons where evidence is going to be led. It is also important to note that when one has now passed on in one of the spouses, and you now sitting with a marriage that is now basically not registered, however valid, and the question is then, what do? You would not be in a position to register that particular estate with the master of the High Court, because one of the requirements is a marriage certificate. So you will have to now redirect who's going to be the respondent in your application. Your in-laws are going to be, because now they are not recognizing you as the wife and or the husband. Before I proceed, Mr. Mnisi, I see there is a question that has been posed. I'm not sure if I will allow you guys. You're more than welcome to ask any questions as I proceed. And should you have any questions, I'm more than welcome to take them at this point. Noting that we had a bit of a delay when starting, I'm more than also welcome to continue just a little bit longer, just to cover up for the time that has been wasted when we were load shedded. Mr. Mnisi, are you there?
Thanks, Counsel. Yes, I'm here. The question is from Lindy, and it reads as follows. What happens when there is a lobola paid and then parties now entered into a civil marriage? The lobola was not considered by both parties as marriage.
Can you please repeat that question again?
Okay, it says, what happens when there is lobola paid and then the parties now entered into a civil marriage? The lobola was not considered by both parties as marriage.
I've dealt with that issue to say, if lobola has been paid by both parties, that constitutes a marriage, whether we like it and whether we don't. And if both parties decide to enter into a civil marriage, that's why I said that what normally happens if the parties informally separate and remarries, I said that a customary marriage is not invalid because one of the spouses entered into a civil union with a third party. And in fact, from the legal standpoint of view, the second marriage between the one spouse and the third spouse will be regarded as null and void. So should any of the parties at one stage decide to say, well, I am now going to issue an application and issue summons because now your estate has subsequently grown and to the value of 4.8 million or 10 million, guess what? I was once married to you. So now that invalidates the second part, where one can bring an application to say that marriage that you have entered into is actually null and void. If one of the other parties decides to bring an application and say, well, I am nullifying that marriage because you entered into a marriage knowingly very well that you are still customarily married to me. I've dealt with that answer to that question specifically, which basically says that when parties do separate, it is also very important that they do dissolve their customary marriage accordingly. Court failure to do so does not invalidate the existence of that customary marriage. Mr. Missing?
Oh, thanks. That's the only question that I see from the chat box. I'm not sure if other colleagues have questions that they would like to ask.
Should I then proceed?
Yes, please. Yes, please.
Okay, I will continue now by dealing with the divorces in terms of the recognition of the marriage of recognition of the Customary Marriages Act. Well, that's Section 8 of the recognition of customer, which provides that a marriage may only be dissolved by a court by a decree of divorce on the ground of irretrievable marriage of a breakdown. I've seen instances where summons are issued, and what is basically attached on the summons is a lobola letter, and the plaintiff will request that a marriage be dissolved and so forth, which is, I think, it's wrong. I'm of the opinion that it's wrong in the following sense, that what is prima facie proof is when one issues when a court orders a final decree of divorce is a marriage certificate, and nowhere in the act, even in the Divorce Act, makes provisions for a lobola letter to be attached as a letter confirming that there was a marriage that existed between plaintiff and the defendant. So one ought to, as the Act is clearly saying, that you need to approach a certain court and to be on application and have your marriage registered, and thereafter order the Home Affairs to register your marriage, and thereafter issue you with the marriage certificate. Thereafter, you can approach the court and to have your marriage then basically dissolved in terms of Section 8 of the Recognition of Customary Marriages Act. Now, it goes also to the grain of what I've been explaining, the importance of having to register a customary marriage and having it registered in line with the Act, so to prevent, imagine the legal costs that one has to incur in order for her to have this issue resolved, where one could have simply just went with as a husband and wife, approach any court or approach the Department of Home Affairs and have their marriage registered and have a marriage certificate issued in their behalf. The problem, legal challenges where it arises where there is failure to comply with Section 4 of the Recognition of the Customary Marriages Act. And then it creates a string of challenges where one has to now look at and deal with in having a certain marriage registered. Now, in dealing with the divorce further, I'm saying that a customary marriage is, as I've mentioned, are all in community property, where, of course, an ANC was concluded. Couples that are just separating formally are not aware that they remain legally entitled to an equal division of the joint estate and claim certain benefits from the either party. Failure to dissolve a customary marriage may create barriers for a party that wants to marry again. For example, a spouse in community of property in a customary marriage will be prevented from entering into a civil marriage with another during the substance of the marriage of a customary marriage. As such, a marriage in terms of the recognition of customary marriage has been addressed. Many imbalances in the past, gender inequalities relating to certain aspects of a customary marriages. It is clear that South African communities still lack the required knowledge of the operation of the application of the Recognition of Customary Marriages Act. We've entered into it, let's say, in 1992. It's post 2023. Your estate increases substantially. We happen to don't see eye to eye with your better half in 2023. But now there has been existing this customary marriage forever. And now this customary marriage has been existing forever. And in 2023, we decided to dissolve it. Can one see the consequences of when we or you and another person started with this customary marriage, and now the state is subsequently grown. We are now in 2023. Now one needs to dissolve, but how do we dissolve it? We ought to have to now first approach the court. Now, how do you even approach the official at the Home Affairs? You need both persons. You need husband and you need a wife that basically says, yes, indeed, on such and such a date, there was a customary marriage that took place. Now, when there's a dispute, as we all know how divorces are, they are quite emotional. There's a lot of emotion. One refuses to go and say, let's agree to have this. One is now left with an option to now bring this application and to have this to be a declaratory order in the court and say, on this date, there was a marriage. This is what basically happened, and I'm requiring and seeking an order to have this declaratory order made in order of court, and the court orders that the Home Affairs issues a marriage certificate. But it does not end there. Seeing that there is a dispute, it will then cause one then to go again to approach the court and issue a divorce summons, whereupon now we are dealing with the division of the estate between both parties. That's basically the nutshell of failure to register a customary marriage. And most people which are basically grappling even in court with the recognition of the customary marriage. It is ultimately important that you understand the Section 4 of the Recognition of Customary Marriages Act thoroughly. And you don't bother yourself to say and approach a court and create a list of authorities with volumes of papers and saying volumes of case law. You will definitely, like I've indicated, matters which are aligned with saying that handing over was not done. But there's other cases contrary to that. And it is quite clear what are the requirements of a customary marriage in terms of Section 31AB. The last element is the proving part. So with one going to court with an argument to say, well, the handing over did not actually take place. No. And one ought to prove in your papers when you are drafting the affidavit. These papers are quite extensive. When you are drafting them, normally they are written in our indigenous languages. There are others that are written in Zulu, Shivenda, Setswana, and so forth. You ought to explain the contents of the letters that are written in any indigenous language that we are currently using. Explain it to, don't just say a copy of this letter is annexed to and marked as Annexure A1. Explain the contents of the letter. If you're going to attach papers or photos of husband and wife celebrating the marriage or celebrating or having a member, so at one state and so forth, you ought to have indicate to the judge, this is the wife and this is the husband. And this is who and this is who. Because you are asking a court to change someone else's status who is now appears to be single to marriage. So the courts are not easily convinced. So you need to, when you are supporting and you are providing an affidavit together with your annexures, attach relevant annexures, proving exactly what you are saying in your founding papers. And in your founding papers, you must always ensure that those annexures that have been attached there indicate and decisively, clearly states who the husband is, decisively state who the wife is. If any other supporting photos that you find to be useful, please include them. But don't burden the court with all photos which at some point are just making an application quite thick and have no relevance to what you are basically saying. So also, lastly, please have a look at to say, am I bringing an application or am I bringing a summons? If for argument's sake, you anticipate that there's going to be a dispute of fact, with greatest respect, colleagues, I do anticipate this. We see it a lot of times where a matter is ripe for hearing, sitting on the opposed roll, is ready to be argued. You find that judge would now basically saying, I am of the opinion that we all can agree that there's a dispute of fact, can then this matter then be removed from the roll, and then we can, it follows the trial motion roll, and where evidence needs to be led, and. So it is utmost important that you understand your case, the merits, upon consultation. It is also important to advise the court. I am bringing this application in terms of the Swati culture. This ought to have happened. I am married. If you were the respondent, you need to then say, I deny the existence of this particular marriage, and for the following reasons why I'm denying it. In my culture, or in my custom as Swati, as Venda, as Pedi, as whatever, this ought to have happened. Don't just rebut evidence with pure denials and not be able to substantiate. You're actually leaving the court to only one aspect of basically deciding to say, ought to basically, discover, to say, to find in favor of the applicant, because what you've mainly done is just pure rebut the evidence of the applicant with bare denials and not substantiating your own version of what ought to have happened if ever you were to be in a position to deny the existence of a particular marriage. So papers in any court, papers in when we are drafting, more especially and most importantly, your notice of motion needs to clearly set out exactly what you require the court to come to, which conclusion, and which relief are you seeking before a court. Because there's nothing as embarrassing where you find papers and that have been prepared, but now you look at the body of the founding affidavit, you look at the notice of motion, it does not correlate, because the notice of motion is seeking a certain relief, but the deposition of the body of the founding affidavit is seeking a contrary relief to the notice of motion. So it is of paramount importance to understand your case at first instance. Am I bringing an application, an interlocutory application, to have a marriage registered? Am I bringing an application to say that there was a marriage that took place and this is how it took place? So can you see, I am saying there was a marriage that took place on such and such a date. And when you do say that, also in your body of your founding affidavit, make sure those lobola postscripts are done by family members and not the plaintiff or the applicant or the respondent. So you ought to have to inquire from your instructing attorneys as to where are these people that attended the lobola negotiations. How many times were the lobola? Normally it will say we met on this date and we still have to meet on the other one. Then they eventually do meet. So those postscripts must be in order. And there are also applicants at stage who also do take advantage of saying there was a marriage and yet there isn't. And if you will find yourself now as the respondent, you will find that in most cases, there was intlawulo that was paid, for the lack of a better word, what we call now damages. You ought to rebut, if you were to saying there was no lobolo, but there was damages that were paid in respect of a child born in that relationship, then you need to be physically, not the word physically, but you need to be extremely sure that is the case. And that letter that was exchanged, if there was, between both families, clearly indicates what was the intention of the meeting between both families. If you're just going to at some point rebut the applicant's version of saying, well, there was no lobolo that was discussed, only discussed in Tlawulo, of the child born in the marriage or born in the relationship, then it must be said so. And go to court with that and be able to rebut that. But don't go to court with the say that the handing over of the marriage it did not actually take place. 9 out of 10, you will not be able to succeed with that argument, because clearly it is not a requirement. The first 3 requirements, if you are saying so, then what are you telling the court about the other first requirement? where there's consent. Did they meet? How long? Were they staying together as husband and wife? Did the parents consent? And so forth. So those are issues that one needs to deal with when you are bringing this type of an application before in any other court, and make sure that you've got all your ducks in a row in as far as the relief that you are seeking and the evidence that you are going to present to any court that makes any distinction that there was a customary marriage that existed between the applicant and the respondent. Of paramount importance, don't just bring an application without including the necessary institutions which you require them to issue a marriage certificate. Because without a marriage certificate, the court will say, I've seen a judgment. The judgment says the court is, yes, I agree, there is a marriage that existed between the plaintiff and the defendant. And you are now stuck because you can't proceed any further. The court said there is a marriage that existed and it ended there. So now we find yourself in a position that now, do I go to Home Affairs? But there is no order ordering Home Affairs to issue a marriage certificate on behalf of the applicant and the respondent. Mr. Missy.
Yes, Mr. Yes.
Should I continue and provide 15 minutes that was not present, that I missed due to load shedding?
Yes, I think you should proceed.
Okay. All right. Two more aspects. If which I would like to deal with are the following. I had a matter where one said to me a while ago, I think about 2 years ago, and said, well, we want to claim lobola back from the chances of that. You need to just tell people from outright. It is not going to, the chances of you succeeding in reclaiming your lobola back, you need to prove to the court certain elements as to why, like in any other divorce summons that one issues against the other, and you further request to say, well, this is what I require, and this is, so to prove all of those elements, it will be highly unlikely that you will succeed. So if a matter, both parties, husband and wife, find themselves to say, now we are now in marriage has trivially broken down, or we're going our separate ways, and I don't wish to be married to you any longer, and so forth. But the problem is one, at that time, during husband and wife, or living together as customary husband and wife, the challenge was that you, on the very same matter, one signed documents at work where he cited the lady as the wife, and with all the benefits and so forth. But people tend to forget about those forms when they separate and go to their various DC or various ways. And it so happened that the husband passed away. And when the husband passed away, the wife instituted an application and said that, well, I have proof because basically all these forms that he submitted at HR were given to me. I was regarded as the wife in his medical aid. I was also provided with documents from his pension fund where I'm cited as a beneficiary in my capacity as the wife. So now this issue is sitting there, and she's saying, well, in view of the fact that he's now passed on, our marriage was never ever dissolved. I wish now, on the strength and on what happened, we cannot deny that my family and his family met. We just decided to go separate ways. If we've decided to go separate ways, it's all okay. But now, the family of the husband is now not recognizing me as the legal wife. It prompted her to bring an application, a declaratory order, declaring that she be recognized as the customary law wife married to the deceased. I see I have a question also from Council Mr. Mlaudzi. It says, what happens if those people who negotiated the lobola are dead from both families? Council, what I would say is it would not prevent you from bringing any application to invalidate, seeking an order to validate a customary marriage, even if those people who attended the said marriage negotiations between both families are no longer alive. What you have to do is to just advise the court to say lobola negotiations took place on such and such a date. The emissaries that I sent to represent me or my family on my behalf are no longer, they've since passed on. But a confirmatory affidavit of my mother or my uncle who was there but was not part of the delegation that attended the customary, the lobola negotiations, can confirm and attest that such negotiations did indeed take place on this particular matter. And if it is probably in the villages, normally they do go and see certain people who then do actually also confirm that there was a marriage that took place. I see I have another question from Ayanda. Oh, sorry, it's an extended question. Is it Asanda Siabonga, or even if those people are dead, remember that Induna or chief must be aware. It's exactly what I was just explaining. In rural areas where there is Induna, there's a whole lot of people that can basically attest. Those people can basically sign a confirmatory affidavit and confirm that yes, indeed on such and such a date, this is what basically happened. It also goes back to what I discussed earlier with the Tsambo in the Singati matter, where thank you, Lazarus. It also goes back to counsel to the matter which I discussed earlier on the Tsambo in the Singati matter, where the courts are basically saying that you ought to treat each and every matter according to its own merits, and you cannot then say, because I don't have this and this is what basically happened. So one is to look at the matter at hand, look at all the documentation that you have in front of you, thereafter be in a position to proceed with your matter according to what you have been presented with and the merits of your matter at a particular time. It is rather wait for your instructing attorney to provide you with all necessary documentation before drafting and settling an application to this effect with limited information. And only to your surprise, when you arrive at court, you are being, when the respondent presents his answering affidavit, you are presented with evidence which you could have dealt with in your founding affidavit. What am I trying to say about this? If you are an applicant this is now generally in any application, inclusive of this type of matters, make sure that you are the one as the applicant who adduces your evidence prior to the respondent producing evidence in their answering affidavit. If you are aware of information, present it, you are the applicant, because half of the time is judges don't actually look at what you already said, what you're going to say in your reply, because you're basically just rebutting all that information that is being said. Your founding papers makes the applicant, and that's why normally you hear the phrase, you stand and you fall with your papers. I have a question from Lindy. It says, in a hybrid marriage where the same couple where lobola was paid, they now entered into an antenuptial contract. They now, instead of a post-nuptial contract and marry out of community. I'm not sure I understand your question quite clearly, Lindy. You're saying that they now entered into an antenuptial contract instead of a post-nuptial contract and marry out of community property. Maybe if you can just clarify your question there, just the last 2, 3 sentences, so it makes sense. Well, in view of same marriages in terms of customary and so forth, they are very rare. If one were to say it, you will find that more or less in civil marriages more than in customary marriages. Even if it were to happen, let's say you have the same-sex marriages of same people, same gender, and so forth, getting married to each other, it's not a problem. If they comprise themselves on the same customs as customary marriage, then a customary marriage will have to exist. If they conform to those statutory requirements, then the statutory requirements will have to adhere to, and that's how they will dissolve. I'll make an example, which is very rare. The Somizi matter and the husband, or the other guy, should I say the other guy? The matter is at now, probably, I think they are trying to settle the matter, if my memory serves me correctly, because it was one of those issues again, where are we saying it was one of those issues where they dealt with the issue of whether is it a civil marriage or a customary marriage, and only to find that indeed it was actually a customary marriage. Now they had to look at the proscripts of the customary marriage. Where did it happen and how did it happen and so forth. So if same-sex marriages do apply, if you conform to this type of a marriage and you enter into this type of a marriage and you say, I want to go through with the customary way, if you subscribe to those forms, you're going to have to follow those forms and that form of a type of a marriage, and then get yourself to register the marriage in terms of Section 4 of the Recognition of the Customary Marriages Act, and ensure that you follow the proscripts in line with the Act, and you register your marriage accordingly. Any questions? Mr. Mnisi?
Thank you very much, Advocate Khaba. I'd like to thank you for making time outside of your busy schedule today in order to be our speaker. We thoroughly enjoyed your informative session, and I would like to thank also everyone who managed to log in and be part of this session. Our next session will be on the first week of June. We'll post it throughout our social media, and thank you. See you next time.
Thank you so much, and thank you for all the attendees. Thank you so much.
Thanks, Council.
Pleasure, sir.